In this lecture, we shall discuss the fundamental human rights provided under the 1992 Constitution. Now, it is important for everybody in Ghana to know the fundamental human rights provided under the 1992 Constitution, because such provisions actually define our existence. And because of its monumental importance in our constitutional framework, the provisions on human rights contained in Chapter 5 have been made entrenched provisions under the 1992 Constitution. And because they are entrenched provisions, it means that they require a special amendment procedure. If you want to make any amendment to the human rights provisions contained in Chapter 5 of our 1992 Constitution, it shall require you to go through a special amendment procedure, which will even involve the whole body politic of Ghana. You would have to go through a referendum involving the whole body politic of Ghana before you can amend them. That highlights the crucial importance of the fundamental human rights provisions contained in Chapter 5 of the 1992 Constitution. Now, before I begin the discussion on Chapter 5 of the 1992 Constitution, it is important to mention that the provisions contained in Chapter 5 of the 1992 Constitution, they begin from Article 12 and they end at Article 33 of the Constitution. They begin from Article 12 and they end at Article 33 of the Constitution. Now, even though Chapter 5 of the Constitution is headed Fundamental Human Rights and Freedoms, it is important to note that there are some other human rights provisions that are still in the 1992 Constitution, but which you will not see under Chapter 5 of the Constitution. For example, the right to vote. The right to vote has been provided for under Article 42 of the Constitution. And this is in Chapter 7 of the Constitution. But you cannot say that because the right to vote is not found in Chapter 5, then it is not a human right. So all I'm saying is that even though Chapter 5 of the Constitution, which starts from Article 12 and ends at 33, even though that Chapter 5 is devoted to fundamental human rights, there are some other human rights provisions that you can see in other portions of the Constitution, like the right to vote contained in Article 42 of the Constitution. And even if you look at Chapter 12 of the Constitution, it provides for the freedom and independence of the media. Freedom and independence of the media. If you look at that Chapter 12 as well, you will find out some important media rights that are guaranteed under the Constitution. Now, even though there are some provisions that are not in Chapter 5, it is important to know that this lecture shall be limited to the fundamental human rights that have been provided for and guaranteed under Chapter 5 of our Constitution, which begins from Article 12 and ends at Article 33 of the Constitution. We shall go through these articles extensively and then indicate how the case law has thrown more light on such human rights provisions contained in Chapter 5 of the 1992 Constitution. Now, before I also begin with a discussion of Chapter 5, you will notice that I mentioned that the fundamental human rights provisions are contained in Articles 12 to Article 33. This indicates the conscious efforts of the framers of the 1992 Constitution to have elaborate provisions to deal with the protection of fundamental human rights. But the framers of the Constitution were very careful in not restricting the scope of human rights that may be recognized and enforced by the courts. And therefore, there is language in Article 33, Clause 5 to indicate that even though a conscious effort has been made under Articles 12 to Article 33, there's a conscious effort to indicate that the rights provided for under Chapter 5 are not exhaustive. And this is what Article 33, Clause 5 says. Article 33, Clause 5 reads as follows, and I quote, "The rights, duties, declarations, and guarantees relating to fundamental human rights and freedoms specifically mentioned in this chapter shall not be regarded as excluding others not specifically mentioned, which are considered to be inherent in a democracy and intended to secure the freedom and dignity of man." Emphasis: shall not be regarded as excluding others not specifically mentioned, which are considered to be inherent in a democracy and intended to secure the freedom and dignity of man. Full stop. So the lawmaker has been careful to tell you that the provisions contained in Chapter 5 shall not be regarded as excluding the others not specifically mentioned, but which are considered to be inherent in the democracy and intended to secure the dignity of man. Now, having said so, I can now begin with the discussion of the fundamental human rights that have been contained in Chapter 5. And as we go through from Article 12, and we strive to get all the way to 33, bear in mind that the rights contained in Chapter 5, starting from Article 12 to 33, they shall not be taken to be excluding rights not specifically mentioned in the chapter, but which are deemed to be inherent in the democracy and to the dignity of man. So we shall now begin with Article 12 of the 1992 Constitution. Article 12 reads as follows, and I quote, "The fundamental human rights and freedoms enshrined in this chapter shall be respected and upheld by the executive, legislature, and judiciary, and all other organs of government and its agencies, and where applicable to them, by all natural and legal persons in Ghana, and shall be enforceable by the courts as provided for in this Constitution." Then Article 12, Clause 2. "Every person in Ghana, whatever his race, place of origin, political opinion, color, religion, creed, or gender shall be entitled to the fundamental human rights and freedoms of the individual contained in this chapter, but subject to respect for the rights and freedoms of others and for the protection of the public interests. Full stop. That is Article 12. Now, there are some key things to note about Article 12 of the Constitution. Article 12 gives a clear indication that even though we have our fundamental human rights of the individual provided in Chapter 5, Article 12 provides that those rights are subject to the respect for the rights and freedoms of others. That even though you have your fundamental human rights and freedoms under Article 12 of the Constitution, such rights are subject to the respect for the rights and freedoms of others and for the public interest. What does this statement mean? It means that the rights and freedoms provided for under Chapter 5, they are rights which are not absolute. They are not absolute. You cannot say that because you have a freedom of speech, so you can speak in whichever way whatsoever that you want. Article 12 clause 2 is saying that even though you have the fundamental human rights and freedoms under Chapter 5, those rights are subject to the respect for the rights and freedoms of others. So remember that even though you have a freedom of speech under Article 21, another person also has a freedom of dignity, right to dignity under Article 15. So if you have the right to dignity, then it means that even though you have your freedom of speech under Article 21, when you are expressing yourself, you should note that it is subject to the right of dignity of another person. So you cannot go somewhere and just be defaming somebody in any way that you want to. Even though you have a freedom of movement under Article 21, remember that people also have right to property under Article 18 and the right of privacy under Article 18. And so even though you have the freedom to move about freely, it means that you must respect the privacy of other persons guaranteed under Article 18, so that you don't just walk into somebody's house and say that I have a freedom of movement. So Article 12 clause 2 is telling us that the rights we enjoy under Chapter 5, they shall be subject to the respect for the rights and freedoms of others and for the public interest. Meaning that the rights contained in Chapter 5, they are not absolute. They are fluid and they are also dynamic. Now, who are the categories of persons who must respect fundamental human rights in Ghana? Look at the language of Article 12 clause 1 very well. It tells us the people who have the obligation to respect fundamental human rights and freedoms. Article 12 clause 1 says that the fundamental human rights and freedoms enshrined in this chapter shall be respected and upheld by the executive, legislature, and judiciary, and all other organs of government and its agencies. It means that we are told that the government is one machinery that must make sure that they are respecting the fundamental human rights and freedoms provided for under Chapter 5 of the Constitution. Article 12 is telling us that the government must uphold and respect the fundamental human rights and freedoms. Because it says the fundamental human rights and freedoms enshrined in this chapter shall be respected and upheld by the executive, legislature, and judiciary, and all other organs of government and its agencies. It didn't end there. It also indicated that all natural and legal persons must also respect the fundamental human rights provided for in chapter 5. All natural and legal persons. It means that the people who must respect the fundamental human rights and freedoms as provided for in chapter 5 is not only the executive, is not only the legislature, is not only the judiciary, is not only the organs of government, but natural and legal persons in Ghana must also respect the fundamental human rights and freedoms of particular persons. And therefore, a natural person, like a human being, would have to respect the rights and freedoms of others. A legal person, a company, must also respect the rights and freedom of its employees. So that is what Article 12 tells us. Article 12 tells us that the people who must respect the fundamental human rights is not only the government, but we also have natural and legal persons. And you will see that under clause 1 of Article 12. And also Article 12 clearly indicates that the rights contained in chapter 5 shall be enforceable by the courts as provided for in this constitution. Shall be enforceable by the courts as provided for in this constitution. In order for persons to understand the statement shall be enforceable by the courts as provided for in this constitution, it is important for good students of constitutional law and lawyers to remember the case of Iriakutu. Because Iriakutu was a clear case example of a case where under the 1960 constitution, when the question was about Article 13 of the 1960 constitution, the Supreme Court held that those declarations made by the president that he was going to respect some rights and freedoms, that those rights, those statements were not enforceable in the court of law as enforceable rights. And so even though people had been detained without trial, the court held that the president had the power to detain people without trial. And the court did not go into enforcing the rights of the people to let them come out because they were detained without trial. That was the situation under the 1960 constitution. And therefore, if you see over here under Article 12, that the rights shall be enforceable by the courts as provided for in this constitution, it is because we know where we are coming from. We know there was a time in our era under the 1960 constitution where there was a question about whether some rights were enforceable in the court of law. And so remember that under Article 12, the human rights provisions are also enforceable by the courts as provided for in this constitution. The next provision is Article 13 of the Constitution. Clause 1 of Article 13 reads as follows, and I quote, "No person shall be deprived of his life intentionally except in the exercise of the execution of a sentence of a court in respect of a criminal offense under the laws of Ghana of which he has been convicted." So Article 13 affirms what we know as the right to life. It says, no person shall be deprived of his life intentionally, except in the exercise of the execution of a sentence of a court, in respect of a criminal offense under the laws of Ghana of which he has been convicted. So Article 13, Clause 1 clearly affirms the right to life, but it creates an exception that even though we all have our right to life, that right to life may be taken away from us in the exercise of the execution of a sentence of a court in respect of a criminal offense under the laws of Ghana of which he has been convicted. So, for example, under Section 46 of the Criminal Offences Act of 1960, Act 29, it has been provided that a person who commits murder shall be liable to suffer death. And so, even though Article 13 of our Constitution guarantees your right to life, under Section 46 of the Criminal Offences Act 1960, Act 29, it is there that your right to life can be taken away from you if it's for the purpose of executing a sentence of the court. Act 29, Section 46, it is clearly over there. So the right to life is not absolute. It can be taken away from you in the exercise of a lawful execution of a sentence of the court. Also linked to Article 13 is Article 3, Clause 3 of the Constitution. Article 3, Clause 3 indicates that if any person by himself or in concert with others, by any violence or unlawful means, you suspend or you overthrow or you abrogate the Constitution, or you attempt to abrogate any part of it, it says that you shall be deemed to have committed the offense of high treason, and on conviction, you shall be given the death penalty. And so Article 3, Clause 3 of the Constitution also provides that a person who commits high treason shall be liable to suffer the death penalty. And so it is not true that the Constitution of Ghana prohibits the death penalty. It's not true. The Constitution of Ghana recognizes the death penalty as legal. So the death penalty in Ghana is constitutional, and it is still in our law books. In fact, as recent as in 2011, in the case of Dexter Johnson versus the Republic, Dexter is spelled D-E-X-T-E-R, Johnson versus the Republic, reported in 2011 through Supreme Court of Ghana Law Report at page 601. In that case, the Supreme Court, by a majority decision, 4-1 majority decision, went ahead to hold that the death penalty provided for under Article 13 of the Constitution and other provisions, that the death penalty was constitutional and it was not in conflict with other laws that were allowing the death penalty. Because the issue was whether the mandatory death penalty provided for under Section 46 of Act 29, that says that if you commit murder, you shall be liable to suffer death. There was an issue of whether that provision there was in conflict with the Constitution. The Supreme Court said that no, it was not in conflict, because the Constitution of Ghana itself, under Article 13, recognizes that even though we all have our right to life, it can be taken away from us in the exercise of the execution of a sentence of a court in respect of a criminal offense under the laws of Ghana of which he has been convicted. And so Article 13 recognizes that even though you have a right to life, it can be taken away from you. In Dexter Johnson versus the Republic, it was held that the death penalty was constitutional. Now, also important to note is Clause 2 of Article 13. Now, you remember that Clause 1 of Article 13 indicated that no person shall be deprived of his life intentionally, except in the exercise of the execution of a sentence of a court in respect of a criminal offense under the laws of Ghana of which he has been convicted. Clause 2 is also very important, and Clause 2 reads as follows, and I quote, "A person shall not be held to have deprived another person of his life in contravention of Clause 1 of this article, if that other person dies as a result of a lawful act of war, or if that other person dies as a result of the use of force to such an extent as is reasonably justifiable in the particular circumstances. A, for the defense of any person from violence or for the defense of property. Or B, in order to effect a lawful arrest or to prevent the escape of a person lawfully detained. Or C, for the purpose of suppressing a riot, insurrection, or mutiny. Or D, in order to prevent the commission of a crime by that person. So usually you hear people asking that if somebody is about to kill you, should you sit down and allow the person to kill you? Article 13 clause 2 is saying that a person shall not be held to have deprived another person of his life. If he can come under any of these, if one, that person used force that was reasonably justifiable in the particular circumstance for the defense of any person from violence or for the defense of property. Meaning that if somebody is about to kill you and then you use force that was reasonably justifiable under the circumstance for the defense of yourself or from any other person, and you end up killing the other person, you shall not be held to have deprived the other person who has died of his life. Because under Article 13 clause 1, because you use force that was reasonably justifiable in the particular circumstance for the defense of another person from violence or for the defense of property. Or if you're also using justifiable force in order to effect a lawful arrest, or if you're using justifiable force to prevent the escape of a person lawfully detained. All of these counts in determining whether a person can come under Article 13 clause 2 to say that he will not be deemed to have deprived another person of his life in contravention of clause 1. If you can come under any of these mentioned under Article 13 clause 2. So remember, Article 13 deals with the right to life, and the death penalty has been held to be constitutional in the case of Dexter Johnson versus the Republic, reported in 2011 through Supreme Court of Ghana Law Reports at page 601. Now, Article 14 is also an interesting provision of the Constitution. It deals with our fundamental liberties. It says that in clause 1, that every person shall be entitled to his personal liberty. So we all have a right to personal liberty. But Article 14, clause 1 was quick to add as follows: that no person shall be deprived of his personal liberty, except in the following cases, and in accordance with procedure permitted by law. And so even though we have indicated that you have your personal liberty, the Constitution itself has provided situations under which your personal liberty may be interfered with in accordance with law. And so we have A to G over here, and all A to G will be given as circumstances under which a person's liberty may be interfered with. And I'm going ahead to mention all of them. 1, or a person's personal liberty may be interfered with in execution of a sentence or order of a court in respect of a criminal offense of which he has been convicted. And so what it means is that if you have been convicted of a criminal offense and then we've locked you up for 20 years, you can't say that the Constitution guarantees your fundamental liberties. No. The Constitution itself says that even though you have your personal liberty, we can take it away from you if it is an execution of a sentence or order of the court. That's Article 14, clause 1A. The 14, clause 1B, that we shall interfere with your personal liberty in the execution of an order of the court, punishing you for contempt of court. If the court convicts you for contempt and they lock you up for some number of days, you cannot complain that you have your personal liberty, because Article 14 contemplates that we can punish a person by restraining his liberty if it's for purpose of punishing him for contempt of court. Again, you can also restrain a person's liberty Article 14 clause 1c says that for the purpose of bringing him before a court in execution of an order of a court. So if the court has ordered that we need to produce you to come before the court, then when we are carrying you to the court, you cannot say that your liberty has been restrained, because Article 14 permits that we can interfere with your liberty if it is for the purpose of bringing you before a court in the execution of an order of the court. Again, the Constitution contemplates that there could be people who are suffering from infectious or contagious disease, or there could be people who are of unsound mind, or there could be a person addicted to some kinds of drugs or alcohol, and there may be the need to keep the person at a particular place for his treatment or for the protection of a community. There was a time in Ghana when we had a report of somebody who was mentally retarded around Kamikuma Circle, who just carried the cement block, hit it against a young man's head and killed him instantly, because this mentally retarded person was allowed to be walking about freely. Article 14 clause 1d is saying that a person's liberty can be restricted if that person is a person suffering from an infectious or contagious disease, or that person is of unsound mind. If we have to detain these people for purpose of either treating them or for the protection of the community, or for the protection of the community. So if you are keeping the people, we can either confine you for the treatment, or it can be for the protection of the community. So when we were experiencing the COVID-19 pandemic and people had COVID-19, when you are kept at an isolated place, remember Article 14 clause 1d says that your liberty can be restrained if you are a person suffering from an infectious or contagious disease, and it is necessary to restrain you in order to treat you or even to protect the community. We can place a restriction on your personal liberty. That's Article 14 clause 1d. Article 14 clause 1e provides that we can also deprive a person of his liberty if it's for the purpose of the education or welfare of a person who has not attained the age of 18 years. So if you're a person below 18 years, we can interfere with your liberty if it's for the purpose of the education or welfare of a person who has not attained the age of 18 years. And so if you're below 18 years and we take you to a boarding school, and then they say that don't go out of the school, and then you say that they're interfering with your liberty. Remember, Article 14 clause 1e provides that we can interfere with your liberty if you are below 18 years and it's for the purpose of providing you with education or for your welfare. Then we have Article 14 clause 1f that says that we can interfere with the personal liberty of another person if it is for the purpose of preventing the unlawful entry of that person into Ghana, or of effecting the expulsion, extradition, or other lawful removal of that person from Ghana, or for the purpose of restricting that person while he is being lawfully conveyed through Ghana in the course of his extradition or removal from one country to another. And then Article 14 clause 1g provides that we can interfere with the personal liberty of another person if there's reasonable suspicion of that person having committed or being about to commit a criminal offense under the laws of Ghana. And so if you have committed a criminal offense and then we come and arrest you and we are taken you to the police station, you cannot complain about an interference with your personal liberty, because Article 14 clause 1g permits us to interfere with your personal liberty if there's reasonable suspicion of you having committed or being about to commit a criminal offense under the laws of Ghana. Article 14 clause 1g permits us to interfere with a personal liberty. Then we move on to clause 2 of Article 14. Clause 2 of Article 14 provides that a person who is arrested, restricted, or detained shall be informed immediately in a language that he understands of the reasons for his arrest, restriction, or detention, and of his right to a lawyer of his choice. So the key things to note about Article 14 clause 2 is that whenever you are arrested, restricted, or detained, you have to be informed immediately, and the information must come to you in a language that you understand. So if you don't speak any language apart from French, and then they are arresting you, the Constitution says that a person who is arrested, restricted, and detained shall be informed immediately in a language that he understands of the reasons for his arrest. So if the only language you speak is Ga, the moment they arrest you, they must inform you in the language that you understand of the reasons for your arrest, restriction, and detention, and they must quickly inform you too of your right to a lawyer of your choice. Article 14 clause 2. Remember, these are fundamental human rights. So it is important that the police officers who will be effecting arrest must be very familiar with the language of the people that they are going to arrest. Then clause 3 of Article 14 deals with the 48-hour rule. What you hear people saying that as a police, they can't detain you beyond 48 hours. Let us see what Article 14 clause 3 says about that. Article 14 clause 3 says that a person who is arrested, restricted, or detained, A, for the purpose of bringing him before a court in execution of an order of a court, or B, upon reasonable suspicion of having committed or being about to commit a criminal offense under the laws of Ghana, and who is not released, shall be brought before a court within 48 hours after the arrest, restriction, or detention. You see what it says? That a person who is arrested, restricted, or detained, if he's arrested or detained upon reasonable suspicion of having committed or being about to commit a criminal offense, then if that person is not released, he shall be brought within 48 hours to a court. So it is not an absolute rule that you cannot be detained beyond 48 hours. It means that once you are arrested, within the 48 hours of your arrest, if you are not released, then the police would have to bring you to a court of competent jurisdiction. And when you are taken to the court of competent jurisdiction, the court can remand you for a further 2 weeks. So the court can remand you again. So it is not true to say that once you are arrested, then you cannot be detained beyond 48 hours. It's that within the 48 hours, you must be arraigned before a court of competent jurisdiction. Yes, that is the clause 3 of Article 14. And then clause 5 deals with people who have been unlawfully arrested, restricted, or detained. It says that a person who is unlawfully arrested, restricted, or detained by any other person shall be entitled to compensation from that other person. And so if somebody unlawfully arrests you, he unlawfully detains you, he unlawfully restricts you, Article 14 clause 5 says that you shall be entitled to claim compensation from that other person. And then clause 7 of Article 14, it deals with a situation whereby somebody has, for instance, been tried by the High Court and been sentenced to maybe 20 years in prison. And then the person has served the 20 years imprisonment, or maybe he's almost done with the serving of the term of imprisonment. And then he appeals, and the Court of Appeal allows his appeal. So that person has now been acquitted and discharged. Meanwhile, he has already served the 15 or 20 or 25 years, as the case may be. Article 14 clause 7 says that such persons are entitled to compensation that the court may think fit. And this is what it says. It gives the power of determining the compensation to the Supreme Court. This is what clause 7 of Article 14 says. A person who has served the whole or part of a sentence is acquitted on appeal by a court other than the Supreme Court, the court may certify to the Supreme Court that a person acquitted be paid compensation. And the Supreme Court may, upon examination of all the facts and the certificates of the record concerned, award such compensation as it may think fit. Or where the acquittal is by the Supreme Court, it may order compensation to be paid to the person so acquitted. So Article 14 clause 7 deals with people who have served their term of imprisonment and then they have ended up being acquitted and then discharged. The Article 14 clause 7 says that the Supreme Court can order compensation as it thinks fit. As far as Article 14 is concerned, it is important that I draw your attention to a provision in the Criminal and Other Offences Procedure Act, 1960, Act 30. Section 104, subsection 4 of the Act 30 provides that if you go and stand as surety for a particular person who has been arrested. You know, when somebody is arrested and then they want to grant the person bail, then usually they will require someone to come and stand in as surety for that particular person. Section 104, subsection 4 provides that when you go and stand as surety for that particular person, and the person absconds and is unable to produce that particular person, then that amount of money that you signed as a bail bond, if it is 100,000 cedis, then you have to pay that money as your punishment. Then he said that if you can't pay that money, then they can go and then sell your movable properties and then attach your movable properties and then use that one to offset the amount of money that you undertook to pay. Now, in the event that you don't have any movable property as well, then what happens? Section 104, subsection 4 of the 30 says that if you can't pay the money, you don't have any movable property to, then you shall be liable to serve imprisonment with hard labor for a term of imprisonment not exceeding 6 months. So previously, you could see a lot of people, when you get stand as surety for bail for somebody, and the person runs away, then they are looking for the person everywhere. The moment they find you, then there's trouble. Then it means that you can go and serve a term of imprisonment. Now, that question has been declared as unconstitutional, that provision in the Act 30, Section 104, subsection 3 and 4. Section 104, subsection 4. It has been declared as unconstitutional because it has been held to be in conflict with Article 14, Clause 1, and Article 19, Clause 11 of the 1992 Constitution. Remember Article 14, Clause 1 of the Constitution. Article 14, Clause 1 says, every person shall be entitled to his personal liberty, and no person shall be deprived of his personal liberty, except in accordance with the following circumstances and as permitted by law. Now, when you mention the instances whereby a person's liberty can be restrained, nowhere did we say, and did we see under the A to G, that if a person goes to stand as surety for bail and then he doesn't pay, then you can go and interfere with his liberty. It's not there. It hasn't been provided as one of the instances whereby you can interfere with a person's liberty. And also, if you look at Article 19, Clause 11, Article 19, Clause 11 provides that every person, if you are going to charge any person for a criminal offense, you must make sure that no person shall be punished for any criminal offense unless the offense is defined and the penalty too has been prescribed in a written law. So you see, under Article under Article 19 clause 11, before you can punish any person for a criminal offense, then you must make sure that that offense has been defined and a penalty to prescribe in a written law before you can go ahead and do that. So if you don't have this one, how then do you go and talk about if the person are not committing any criminal offense, and I only came to stand as surety for a person for bail, and that act is not a criminal offense, how then do you cause me to be imprisoned for months? So that provision in section 104, subsection 4, which said that if you go and stand as surety for a person for bail, and the person absconds, and you don't pay the money, you shall be imprisoned. That provision has been declared as unconstitutional by the Supreme Court in the case of Martin Tebu versus the Attorney General. Martin Tebu versus Attorney General. And this, the citation for this case, the unreported citation of this case is writ number J1/7/2015. And the judgment is dated 3rd December 2015. The Supreme Court held that the provision in section 104, subsection 4 of Act 30, which enabled the court to imprison people who stood as surety for bail, that those provisions were in conflict with Article 14, Clause 1, which guaranteed our liberties, and Article 19, Clause 11, which says that it is only people who have committed criminal offenses who shall be punished by the courts. Since standing as surety for a person is not a criminal offense defined in any law, you can't imprison a person for it. Also important to note is the provision in section 96, subsection 7 of the same Criminal and Other Offences Act, 1960, Act 30. You will notice that under section 96, subsection 7, some offenses have been labeled as non-bailable offenses. It says that a court shall refuse to grant bail in the case of acts of terrorism, treason, subversion, murder, robbery, offenses listed in Part 1 and 2 of the Narcotic Drugs Control and Foreign Sanctions Law, hijacking, piracy, rape, or escape from lawful custody, or where a person is being held for extradition to a foreign country. Now, for any of these ones, a court shall refuse to grant bail. It means that if anybody has been charged with any of these offenses, if I go and report you today for an offense of murder, if you go by section 96, subsection 7 of Act 30, it means you are not supposed to be granted bail at all. Now, what is the import of this particular provision? In order to appreciate the import of that provision, look at Article 19, Clause 2C of the Constitution. Article 19, Clause 2 says that a person shall be presumed to be innocent until he is proved or has pleaded guilty. If I'm supposed to be presumed to be innocent, why do you tell me that the moment you charge me for murder, I'm supposed to refuse bail forever until the case is over, so that you will lock me up for 5 years until the case is over? If I'm presumed to be innocent, why do you say that as soon as I'm charged for murder, I should be locked there forever until the case is over? And what does that say about Article 14, Clause 1, that guarantees my personal liberty as an individual? And so, once again, in another case of Martin Tebu, once again, Martin Tebu versus Attorney General. This one is writ number J1/13/2015, and the judgment is dated 5th May 2016. In this case, the Supreme Court held that the provision in section 96, subsection 7 of the Act 30, which made some offenses non-bailable offenses, that provision was in conflict with the presumption of innocence under Article 19, Clause 2C, and our personal liberty under Article 41. And therefore, the provision contained in Section 96, Section 7, making some offenses non-bailable, was unconstitutional. So today, the Section 96, Section 7, that made some offenses non-bailable, those provisions have been declared as unconstitutional and they've been struck down under our law. So now in Ghana, all offenses are bailable. All offenses are bailable. But before a court will grant bail, the court must be guided by section 96, subsection 5 and 6 of the Act 30. It has given some guidelines the court must consider before they grant or refuse bail. Section 96, subsection 5 and 6 of the Act 30. So if you look at section 96, subsection 5, it says that a court shall refuse to grant bail if it is satisfied that the defendant A may not appear to stand trial, or B may interfere with the witness or the evidence, or may in any way hamper police investigations, or C may commit a further offense when on bail, or D is charged with an offense punishable by imprisonment exceeding 6 months, which is alleged to have been committed while the defendant was on bail. So if any of these can be proven, then the court shall refuse to grant bail. If the court sees that you will not appear to stand trial, or you are going to interfere with the witnesses, or you may commit a further offense while on bail, these are all grounds under which the court may refuse to grant bail. And under section 96, subsection 6 of the Act 30, it says that when the court is considering whether to grant bail, it shall take into account A, the nature of the accusation, B, the nature of the evidence in support of the accusation, C, the severity of the punishment which convictions will entail, D, whether the defendant, having been released on bail on a previous occasion, has willfully failed to comply with the conditions of the recognizance entered into by the defendant on that occasion. E, whether or not the defendant has a fixed place of abode in the Republic and is gainfully employed. And F, whether the sureties are independent, of good character, and of sufficient means. So these are factors the court is supposed to take into account in deciding whether to grant or to refuse bail. So for today, because of the case of Martin Tebu versus the Attorney General, that provision in section 96, subsection 7, that made some offenses non-bailable. We have struck out that provision from our laws. It is unconstitutional, so it's no more part of our laws. So now every offense is bailable. But when the court is going to grant bail, the court must be guided by the requirements in section 96, section 5 and 6 of the Act 30. It means that it's not automatic that they will grant you bail, but the court will be guided by those considerations. So we have dealt with the right to life under Article 13, we've dealt with Article 12, and we have dealt with Article 14. And Article 14 is very extensive. Remember that because of Article 14, that provision that indicated that when you go and stand as surety for a person and the accused person runs away, that provision in the Act 30 that says that we can imprison you, it has been struck out as unconstitutional. Again, to the glory of Article 14 and Martin Tebu, those provisions in the Act 30 that made some offenses non-bailable, those provisions too have been declared as unconstitutional. But remember, we are not saying that every offense is bailable, and so automatically, you will always automatically get bail. Remember that the court, in deciding whether to refuse or to grant bail, shall be guided by the nature of the offense, nature of the accusation. We shall find out whether you are somebody who will not appear to stand trial, whether you are somebody who may interfere with the witnesses, whether you are likely to commit a further offense when on bail. The court will consider all of these in determining whether to grant or to refuse the bail. This is where we shall wrap up with our lecture in this particular lecture. Since we have been able to discuss Article 12, we have discussed Article 13, we have discussed Article 14. In our subsequent lectures, we shall deal with the other rights contained in other provisions in Chapter 5 of the Constitution. Thank you.